Welcome to Building Your Legacy, Southern Arizona Estate Planning with Allison Manning.
Hello, everyone. Welcome to Building Your Legacy in Southern Arizona with attorney Allison Manning. Allison is an estate planning attorney who helps individuals and families across Southern Arizona create clear, practical plans for the future. She works closely with clients on wills, trusts, powers of attorney, and long-term care planning, with a focus on making sure those plans actually work when they're needed. I'm Sean O'Connor, and in this episode, Allison and I are talking about how probate actually works, what triggers it, and how families move through the process step by step here in Arizona. Allison, good to see you.
Hi, Sean. Thanks for having me.
You bet. Okay, let's probate. What is probate in Arizona, and what does the process actually involve?
Great. The probate process is a court process. The probate court is the only institution after you die that has the authority to change the name on titled assets from your name when you're deceased to your beneficiary's name. It can be a lot of paperwork and can be a convoluted process. It is a public process. Anyone who wants to know what's happening in the court system can go down and find out. But it is the process to change documents or accounts and assets from your name into the name of your beneficiaries.
Got it. So, talking about changing names on assets, what types of assets are we talking about that usually go through probate in Arizona?
So typically, assets that go through probate are going to be assets like real property, where your house is, land. It also can be bank accounts. It can be brokerage accounts. It can be a life insurance or an IRA, again, if they don't have beneficiaries on them. Other assets that pass through that a lot of times people forget about are businesses that they may own, like an LLC or stocks that are certificated.
You mentioned beneficiaries, makes me think of wills. What happens in Arizona if someone passes away but they don't have a will?
It's a good question. That process is what we refer to as dying intestate. Intestate means you die without a will. The state of Arizona has gotten together and in their statutes has designed the will for you if you die without a will. This is one where the state says who is your next of kin who gets your assets and who is the one who has the highest priority of being able to be the personal representative or the one in charge of your estate. Most of the time, clients that I meet with want some say in who's in charge and where assets go, and they don't want to rely on the plan that the state has designed for them. And if the state can't find your heirs, then the assets eventually get passed over to the state of Arizona to be held in unclaimed property.
Okay. I think that's another episode on unclaimed property archives. Wow. So someone passes away. What triggers the probate process? How does that begin?
Well, typically how it begins is actually, it begins before you even get to the courts, is that someone's account's frozen. And I get a panicked call from someone saying, I can't access my money. And they are in a time of crisis because they can't access money because someone's died. But technically how the actual probate process starts is when somebody files an application to be appointed either in an informal probate or a petition to be appointed in a formal process to be appointed as a personal representative and open that. It's followed by many other documents and notifications that must be sent out along with trainings that need to be completed. Possibly a bond that needs to get issued to secure the estate value. But that's how the process gets started, is through that initial application or petition.
I see. And would that be the same for, whether there's a will or someone died intestate, if that's the right usage there?
Yeah, it is the same beginning process, whether or not we have to file an application or petition. What it depends on is whether or not, which type of process, which type of probate we're going through, whether we have to file an application or petition. But sometimes when we don't have a will, we have to go through a hearing process to determine who's the right person to be the personal representative. And so it's not as smooth as a transition if we were to have a will versus not having one.
Is a personal representative the same as an executor?
That's a great question. Yes. In Arizona, we refer to them as personal representatives, but a lot of my clients, many people are used to the term executor. That's the person who has the fiduciary obligation to manage the estate, to make sure that the assets are secured, make sure that beneficiaries and heirs are notified, and that the creditors also receive their notification and due process.
Got it. So the role's the same, and they both have the fiduciary responsibility, but just Arizona's jargon is personal representative versus executor.
Right, because we
Okay.
just have to make it a little more complicated to say it than that quick executor.
No, for sure. I mean, the more syllables, the better.
Absolutely.
I mean, I'm all about the multi-syllabic phrase.
Right. And then we can always shorten it and just call them the PR or something to
Oh,
get like fancy too.
sure, sure, sure. Talk about time, right? How long does probate? Because you hear stories like, oh my God, forever. How long does probate usually take in Arizona? And and what affects that timeline?
So a probate can take anywhere from, I'd say, 4 months to typically, I would say about 9 months, maybe a year. I've had probates that have gone on for years, especially when we have businesses involved and we have a sale of a business or real property. We have a sale of real property. We know that can take some time to get things closed out, but we do have the minimum of the 4 months, and that's because of the notice to creditors, those unknown creditors that we have to publicize, and we have to give them 4 months, to make a claim. And additionally, we have to think about, oftentimes we have to file a tax return, and so
Yeah.
it depends on the time of year when someone passes away. Do we have to keep it open in order to file their final tax return plus the estate return that's involved in that? And so we all know when tax time is, and that sometimes keeps the estate open a little bit longer in order to get those taxes done.
You mentioned tax, the time of year that could slow probate down. What other things add complications? I mean, I'm sure there's a million different examples, but besides the IRS.
There's a few other things besides the IRS. IRS always likes to slow things down, but as far as a business sale, many people own a business and they pass away. Let's say I have a client who's an electrician, passed away, looking to sell the business to another party that's going to come in and take over their clientele. That negotiation, the valuation of the business, not only can it be expensive, it's time consuming. Additionally, real property. I mean, Arizona's been known for having healthy real estate markets, but there's better times in the year than others when property sells. And so oftentimes the sale of a property can slow things down and can keep an estate open. There's a few other times where we would see the estate staying open, possibly if there's a lawsuit in the estate, an underlying litigation matter that would keep it open, or just other regulatory matters that may be involved that just, again, keep things open, such as when we look at someone who was on government benefits or who possibly lived internationally and had assets in other countries.
Yeah, just housekeeping that needs to be done. But also, interesting that can also just be a strategy like, oh, let's wait to sell the property until whatever months when the market's better. So
Right.
it's not
And
always.
I would say the other time when we keep things open, it's not intentionally. It's because a creditor is trying to get additional money, or a heir is challenging a will or challenging something. And so now we have litigation that's involved. And having a probate open makes it a little bit easier for someone to make a claim against the estate because they don't have to open a matter. It's already open for them just to object.
Are there different types of probate in Arizona?
There are. So when we refer to the main probates that we talk about, we have your ways of opening up the probates. You have your informal and your formal probates. We also have the supervised and unsupervised. So we open probates most of the time informally, and that's where we file paperwork with the court system and get appointed without having to have a hearing in front of a judge to have the personal representative appointed. There's still the same fiduciary obligation, and it's the personal representative assumes their responsibility through verified statements that they sign on documents. Other times we have to open the probate formally, and that's where we go before a judge and have a hearing, which also can delay the appointment of a personal representative because we have to get on the court calendar system and have that hearing. This is when maybe a will we already know is being challenged, or they don't have a will and multiple parties want to be the personal representative of an estate. Sometimes we have to open it formally because we don't have an original will. It was lost somehow, but we have a copy of a will that we believe was the true original will. And then comparing the format and how we open it, we actually have a method that's referred to as a supervised probate. And that's where the court is hands-on involved in every step of the way in what the personal representative is doing. And they must seek approval when they sell the property and sell assets. Things are going to be held in more of a secure manner. Maybe when we know there's some litigation and challenges, or when there's just some other concerns about how the estate is being managed. But most of the time we have an unsupervised court proceeding, and that's where the personal representative is able to sell assets without having to go back to the court and ask for permission.
And, at the beginning of the process, does one have to understand these different types of probate, or does it essentially happens? I'm not going to file or initiate the wrong type because certain criteria are going to come into play.
It depends on what you file with the court initially. So if you file an application for appointment from an informal probate, that's going to send you through the informal process. If you file a petition for appointment of a personal representative, that's going to send you through the formal process where they're going to set a hearing date. I would say that you can accidentally file the wrong one if you don't have the right information, or if you're doing it on your own and you select the wrong forms. But majority of probates that I open for clients are through the informal process, and you can close it formally. So just because you open it one way doesn't mean you have to close it the same way either.
Is it possible or even desirable to avoid probate in Arizona? Is that something that people do, or is an option?
It's absolutely desirable to avoid probate. So as you had asked me earlier about the different types of assets that go through probate, many of these assets have the ability for you to have beneficiaries designated on them. Even real property. In Arizona, you can file a beneficiary deed, which can allow for the property to transfer without going through the probate process. Oh. Most life insurance have beneficiaries designate them, and IRAs or retirement accounts. But you can also have beneficiaries designated on bank accounts and brokerage accounts. Now, sometimes we don't want to do that. We want to provide protection for our beneficiaries, and so we want it to go through a trust, which is another valuable tool in avoiding probate, having a trust that's drafted and having those assets transferred into the trust during your lifetime. So using either of those methods, we tend to avoid the probate process.
Got it. Oh, got it. So yeah, I was thinking, as you were saying, that you can take a piece of property and do a beneficiary deed, which was news to me. But that would still be potentially a public, people could access that information if they wanted to. And versus with a trust, you're going to, in addition to other benefits, there's a privacy component there, I'm thinking.
Absolutely. Absolutely. A trust gives that privacy component. It also takes into account the status of your beneficiaries. So if you have a beneficiary who's special needs on government assistance, or you just want to provide them with creditor protection or divorce protection, you can do that in a properly drafted trust agreement. And so it provides a lot of privacy and protection for your beneficiaries when they receive assets. Plus, a trust also helps you when you're alive, where, again, today we're just really talking about what happens when you die, but we want to also look at some protection.
What happens if you never die?
Well, we'll figure that out when I have someone who never dies. But, right now, most people actually understand the fact they're going to die. I hate when I have to break the bad news to people that at some point in their life they're going to die. Just because you avoid planning for probate doesn't mean you're going to be alive forever. It just means you're going to die without a proper plan in place. And so we don't want to bury our head in the ground and pretend that that's not going to happen. Plan for it, and hopefully you'll never need it.
Clients come to you, a relative has passed. I'm thinking they didn't know what to do, or they did something wrong, or, what's the first step? You know what I mean? Like, okay, I'm listening to, people out there listening to this podcast. They're like, okay, as you said, people die and someone close to me dies. What's the first step I should take in terms of the logistics of this? Obviously, grieving and such aside,
Usually I say the first thing, for my clients, I tell them to call me the first thing. Don't call banks, don't call financial institutions. While we want to get them that information and secure your assets soon, we don't want them to freeze accounts until you have the ability and the control under your own timetable. And they'll do that because that's their responsibility, is to freeze those assets. But giving me a call or giving your attorney a call, asking, letting them know that your loved one has passed away, so that they can make sure that you understand what your responsibilities are under the documents, and that you take the actions in a reasonable timeline to probate them if necessary, and get them into the courts. But definitely take care of your family first. Take care of the funeral time and mourn together. But having that initial consultation, or that initial conversation, that consultation with your attorney to find out, what do I need to do first? Like I said, don't tell the financial institutions anything till you get that advice.
Good stuff. Well, Allison, we're up against time here. Great to talk to you.
Thank you, Sean. It was great talking with you.
That's it for today's episode of Building Your Legacy in Southern Arizona with Allison Manning. If you're thinking about how probate might affect your family, or you want to understand more the steps you can take and how to make things easier down the line, this is exactly where thoughtful planning can make a difference. And you should go to Allison's website at AllisonManningLaw.com to get more information and to be in touch with her. Thanks for listening, and don't forget to subscribe, share a link to the episode, or leave a review so that other Southern Arizona families can find this valuable information. I'm Sean O'Connor. Have a great day.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.